Under New York law, a vehicle that hits another vehicle from behind is presumed to be responsible for the happening of the accident. However, in this case, there was a bit of a twist. My name is Joseph Donahue, and I'm a partner here at Block, O'Toole & Murphy. Our client was involved in a motor vehicle accident on the Long Island Expressway. He was a union worker coming home from work when he was hit in the rear by a truck that was driving eastbound on the Long Island Expressway. As a result of the accident, our client sustained an injury to his cervical spine, his neck. Ultimately, due to ongoing pain and limitations to his activities, he required a surgery, a one-level cervical fusion, which took place in his neck. The impact on our client was significant. For a period of time, he was not able to work. He also was not able to engage in activities that he typically engaged in, things like riding his bike or playing with his children. Ultimately, due to the surgery that he had, he was able to return to work, but he wasn't able to perform the same tasks as he had done previously. In this case, we argued that the defendant was responsible for striking our client's vehicle in the rear. Under New York law, a vehicle that hits another vehicle from behind is presumed to be responsible for the happening of the accident. However, in this case, there was a bit of a twist. The defendant driver accused our client of cutting him off at the last minute and slamming on his brakes. In that situation, the driver of the rear vehicle may not be at fault. The defendant in this case was adamant that our client cut in front of him at the very last minute and slammed on his brakes, and so he could not avoid hitting our client's vehicle. We brought a lawsuit in Queens against the defendant driver, the owner of his truck, and his employer. After discovery and after all depositions took place, the parties attended a mediation. A mediation is when parties go before a neutral party and engage in settlement discussions to see if the case can be resolved. We were successful in a mediated settlement prior to trial, and we settled the case for $1,200,000.